Okay, folks, we're just going to give it just a couple more minutes just to let everyone in out of the waiting room, and then we'll get started. I would like to introduce to you, on behalf of Law Side of Nunavut, I'd like to introduce Dawn Pritchard, who is called in Ontario and in Nunavut. She is a lawyer in private practice who does a variety of different areas of law, including species at risk and policy issues. And she is a Métis lawyer as well. So without further ado, I will turn it over to you with great thanks for being here today, Dawn.
Yeah, thank you. Thank you for having me and welcome everyone. I'm glad you all showed up. Um, I was preparing the presentation and I was thinking this is really boring, but it isn't really. It's just a bit technical. I've been I live in Wakefield, like Rebecca does, practice out of Ottawa, Nunavut, and Saskatoon as well. I spent about close to 10 years at Environment Canada Legal Services working on the Species at Risk Act, the Migratory Birds Convention Act and regulations and other conservation and harvesting matters, along with the interplay with the land claims agreements. So I've been on my own almost 3 years now, working for Indigenous governments, Indigenous representative organizations, and Indigenous corporations. Recently, I have permission from my client to say this, but I just finished an Inuit-specific legal review of the Species at Risk Act for Inuit Tapiriit Kanatami. So it's still in draft form, waiting approval, but it uh, falls into this work for sure. Next slide, please.
Ah, worked. Okay.
There we go. So I'm going to give you kind of a high-level overview of the Species at Risk Act, and I call it by its acronym SARA, like an old friend Sarah. I'll give a general overview. I'll talk about how Indigenous peoples and Inuit fit into the Species at Risk Act, and I'll talk a bit about the interplay with the Nunavut Land Claims Agreement, and we'll do a little hypothetical listing scenario. So next slide, please. The Species at Risk Act is federal legislation. It became law on December 12th, 2002, and it was designed to meet one of Canada's commitments under the Convention on Biological Diversity. That Article 8K required signatories to, as far as possible and as appropriate, develop or maintain necessary legislation for the protection of threatened species and populations. And you'll see that has all the typical UN qualifier words, but Canada made legislation anyways. Next slide, please. So before SARA was made into law, there were questions about its constitutional basis. And some argued that legislation over wildlife, like other natural resources, rests primarily with provinces. Others argued that the feds have competence under the peace order and good government power. But in the end, environmental laws shared jurisdiction. But in the case of SARA, the feds can tread on provincial and territorial jurisdiction, especially if provinces and territories aren't effectively protecting listed species or critical habitat of those species. And you'll see how SARA plays out a lot of times is where species are located and what kind of species they are. For example, migratory birds and aquatic species fall under federal jurisdiction. Other species that are located on federal land fall under federal jurisdiction, and same with provinces and territories. If the species are located on provincial land or territorial land, they fall under that jurisdiction. Next slide, please. The purpose of SARA is to prevent wildlife species from becoming extinct or extirpated, to provide for the recovery of extirpated, endangered, or threatened species because of human activity, and to manage species of special concern to prevent them from becoming endangered or threatened. And yeah, next slide, please. There's a lot of references to Indigenous peoples in the Species at Risk Act, and that's set out in the preamble and some of the committees and subcommittees in COSEWIC. That's another acronym that I use, and we'll hear more about that, their function in a bit. Requirements to incorporate Aboriginal traditional law, knowledge, reference to land claim agreements, and cooperation with wildlife management boards. It used to, until the end of last year, contain a non-derogation clause, and this was repealed and replaced by the Interpretation Act, a new one contained in the Interpretation Act that says every enactment is to be construed as upholding the Aboriginal and treaty rights of Indigenous peoples recognized and affirmed by Section 35 of the Constitution Act 1982, and not as abrogating or derogating from them. And so this was a fairly big change. The Land Claims Agreements Coalition had lobbied for this amendment for years. Some groups recognized that the amendment is an improvement and supported its passing, but others say it didn't. It failed to meet the standards of the UN Declaration, Action Plan Measure 2. But that's another issue. Next slide, please. The preamble to SARA says the roles of Aboriginal peoples of Canada and of wildlife management boards established under land claims agreements in the conservation of wildlife in this country are essential. So that's a fairly big point. The next one is that the traditional knowledge of the Aboriginal peoples of Canada should be considered in the assessment of which species may be at risk and in developing and implementing recovery measures. It's just, the real question is, how does that all play out in real life? So next question, next slide. I'm happy to answer questions, by the way. Just put up your hand, or if you write something into the chat, Santana will check and can ask on your behalf. So some of the players in SARA are the Minister of Environment, the Minister responsible for parks, the Minister of Fisheries and Oceans. And generally, when I refer to the minister in this presentation, I mean the Minister of Environment. There's the provincial and territorial ministers. There's the National Advisory Committee on Species at Risk, otherwise known as its acronym NACASAR. There is the Committee on the Status of Endangered Wildlife in Canada, that's COSEWIC. The Aboriginal Traditional Knowledge Subcommittee, the ATK Subcommittee, and Wildlife Management Boards, established under the land claim agreements. So next slide, please. So the steps in SARA generally are first to assess the species, to list the species, and then to protect the species, which sets out the consequences of listing. So I'm just going to tell you the definitions of the listings. And extinct means a species that no longer survives in the wild. Extirpated species, that means a species, wildlife species that no longer exists in the wild in Canada, but exists elsewhere. Endangered species means a species that is facing imminent extirpation or extinction. A threatened species means a wildlife species that is likely to become an endangered species if nothing is done to reverse the factors leading to its extirpation or extinction. And a species of special concern means a wildlife species that may become threatened or endangered because of a combination of biological characteristics and identified threats. Next slide, please. So we have NACASAR, the National Aboriginal Council on Species at Risk. And this is supposed to be a direct line to the minister to have the voices of Indigenous peoples heard. It's the advisory council to the Minister of Environment and Canadian Endangered Species Conservation Council, which is made up of the ministers, the provincial ministers, etc. It's comprised of 6 members representing the Indigenous peoples of Canada, and ITK, Inuit Tapiriit Kanatami's representative last I heard was Barry Ford. So it's supposed to be a direct line to the minister, but it doesn't always work that way for a variety of reasons. Next slide, please. So COSEWIC. They must carry, COSEWIC's job is to assess species and to categorize them. It's independent to the Minister of Environment. Um, It must carry out its functions using the best available information on the biological status of a species, including scientific knowledge, community knowledge, and Aboriginal traditional knowledge. And so what happens at these COSEWIC meetings is that the people vote. The voting members vote on how a species should be listed. Now, the voting members are primarily scientists. They're wildlife biology experts from academia, government, non-governmental organizations, and the private sector. Now, we have also the Aboriginal Traditional Knowledge Subcommittee, who has a vote at the table, but they have only one vote. And the Inuit themselves don't have a voice at the table. And Bruce has asked if COSEWIC existed before Sarah, and the answer is yes, it did. And I didn't catch the rest of the question. But Bruce, do you want to?
Don,
Yeah.
yeah, the question is just what COSEWIC did in its like how did it function? What was its role and responsibility? Did it exist under like Canada Wildlife Act or some other uh or is this Sarah the first time that this became formalized?
Um, I couldn't tell you for sure. I understand that they were around before. I don't know how they functioned or what, the short answer, Bruce, is I don't know. Um, I know how they function now, but I couldn't say how they functioned and what their role was really pre-Sarah. Um, I know that they have subcommittees, including the Aboriginal Traditional Subcommittee, but they might have like a subcommittee on mollusks or certain kinds of species, certain kinds of aquatic species, whatever. It's very, very science oriented. Um, the ATK subcommittee has struggled to fit into the COSEWIC framework. Um, Part of it, well, there's a lot of reasons for that. The ATK subcommittee does a lot of work with very little resources. Although COSEWIC is required to consider the best available Aboriginal traditional knowledge, it often doesn't even get to that point because the ATK subcommittee has so little resources that they're not able to collect and incorporate that knowledge. Um, and there's big issues. And another issue is that the ATK subcommittee is required to review and vote on every single species that comes to COSEWIC. So most species don't impact Indigenous peoples, even less impact Inuit. So they're required to do all this work to vote on species that are not important to them. So, Bruce, I didn't really answer your question, but yeah,
That's okay. Can I follow up a little bit?
yeah, sure.
So I also don't know what COSEWIC did, but what I know is that when, for example, there was a quota on caribou or something, there would have been an extinction declaration, like a declaration of game at risk of becoming extinct. And that was kind of what was used for conservation measures. So I asked because COSEWIC has become a technical resource for the government's species at risk program and kind of shepherds, as you've explained, this assessment process to determine the status of a species. and I'm just trying to connect the dots between that and what was used to, for example, put a quota on caribou.
Yeah. Yeah, and you could contact COSEWIC. The one of the co-chairs of COSEWIC is he's from NTI, and his name escapes me. But I can get that name to you if you'd like to find out more.
Could it be Paul Ilnout? Hi, Don, it's Marie here, Marie
Hi,
Ballou.
Marie.
Could it be Paul Ilnout?
No, it's oh geez, what's his name?
Oh, anyways, we can figure it out after.
Yeah, it'll come to me. I know him. I can picture his face. But I cannot remember his name right now. Sorry about that. I have it in my emails, but I have my emails closed right now.
And Don, maybe just to conclude this then, John Donaghy's in the chat as well and has made a comment about a policy that predated SARA that facilitated the COSEWIC function. So
Okay.
I can follow up, and I've got kind of a breadcrumb trail. So yeah, thanks very much for the chat.
Yeah, you're welcome. Okay. The other thing is the ATK subcommittee speaks on behalf of the species and not behalf of Indigenous peoples. So next slide, please. The process to list species is that the minister receives the COSEWIC assessment within 90 days. The minister has to include some kind of response in the public registry. And then the minister ultimately makes a recommendation to the governor in council. So before recommending to the governor and council, the minister must take into account the COSEWIC assessment. The minister must consult the competent ministers, which would mean fisheries and parks, if it's not the same person. If the species is in an area managed by a wildlife management board, they have to consult the board and follow what the land claims agreement says. And we'll get into that in a little bit. Then the minister makes a recommendation to the governor and council, the GIC. And at that time, the GIC lists the species, they decide not to list, or they refer it back to COSEWIC. If GIC does nothing after 9 months, the minister is supposed to amend the list as per COSEWIC's assessment. Next slide, please. Species of special concern. That's a species that may become threatened or endangered due to biological characteristics or threats. Harvesting can continue. A management plan must be prepared within 3 years. There has to be cooperation with wildlife management boards, and the provisions of land claim agreements must be followed. Polar bear are listed as a species of special concern, and ringed seal, last I looked, were assessed as a species of special concern, but the GIC decision to list them was pending. Next slide, please. Next, we look at what happens to threatened, endangered, or extirpated species. Northern fur seal were assessed as threatened, but the GIC decision for that listing is pending. But once species are listed as one of these, prohibitions can kick in. And this could ultimately mean no Inuit harvesting. There's prohibitions from killing, possessing, selling species, protecting critical habitat. When you actually look at those sections in the Act, they're absolutely confusing. You start reading it and it's like, oh, okay, this is clear. But then it's like, okay, this doesn't kick in unless this other thing kicks in. Or this only applies if this other thing applies. Or this only applies if an order is made, and an order can only be made in these circumstances. So it's like super, super confusing. Don't feel bad if you don't understand it when you read it. It's just kind of crazy. It's like everything's contingent on everything else. Anyways, for the prohibitions can apply kind of automatically to aquatic species and their habitat, which is federal, to migratory birds wherever they're located, but not the land on which the migratory birds would be found unless it's federal land, and to other species located on federal land. Otherwise, there needs to be an order made. In the case of the territories, if the territorial laws do not effectively protect species or residents, the minister must recommend a protection order, and the order would only apply to terrestrial species located on territorial land. So that's just kind of like a high-level summary, but the main point of it is that it's pretty confusing, and the feds don't often do protection orders on provincial or federal land. Next slide, please. So if species are listed as extirpated, threatened, endangered, then a recovery strategy has to be prepared. Following that, an action plan within those critical habitat is identified. And these must be prepared in cooperation with wildlife management boards, other Aboriginal organizations directly affected, and according to provisions of land claims agreements. Next slide, please. There are some exceptions to the prohibitions from killing and possessing, and 83 sub 3 provides that the prohibitions don't apply to a person engaging in activities in accordance with conservation measures for wildlife species under a land claims agreement. And paragraph 83(5)(b) provides that prohibitions do not apply to a person who possesses an individual of a species at risk or a part of it if it's used by an indigenous person for ceremonial or medicinal purposes, or part of ceremonial dress used for ceremonial or cultural purposes by an indigenous person. Next. So together with the Species at Risk Act, we have the Nunavut Land Claims Agreement, and it works in tandem with the SARA process for listing species, which could trigger harvesting prohibitions. It works together preparing management plans, recovery strategies, action plans, and the Nunavut Land Claim Agreement says at 5.2.33 that government retains ultimate responsibility for wildlife management, but the Nunavut Wildlife Management Board is the main instrument of wildlife management in the Nunavut settlement area and the main regulator of access to wildlife, and has primary responsibility in relation to certain functions, including establishing, modifying, or removing levels of total allowable harvest. In addition, the Nunavut Wildlife Management Board can approve plans for management, classification, protection of particular wildlife, including endangered species, and approve designation of rare, threatened, and endangered species. So they have authority over these things, and we'll speak to, actually, we'll go to the next slide and show how this would play out in the context of a listing. So what happens is the minister would notify the board that it intends to list a species. So in this hypothetical situation, we'll just pretend that the board decides that the species shouldn't be listed. And so what we're looking at is the Nunavut Agreement Articles 5.3.16 to 5.3.23, which is the legal effect of decisions for Government of Canada jurisdiction. And there's similar provisions under 5.3.7 to 15 for territorial government jurisdiction. And so here, the board decides that the species should not be listed. So it sends its decision, and the language is that the board makes a decision. It's not that the board makes a recommendation, it makes a decision, it sends it back to the minister. The minister in this situation will say disagrees and rejects the board's decision. So the minister sends the rejection back to the board, giving reasons why he rejected that decision. The board then reconsiders the minister's rejection and the reasons, because the reasons are quite important. If the minister doesn't send reasons, then that decision isn't valid. So the minister reconsiders the minister's rejection and reasons, and it issues its final decision. So in that case, the board, in this hypothetical, say the board disagreed again. The minister then reviews the board's final decision, and say the minister rejects that decision. The minister again must provide reasons. So next slide, please. So once the minister accepts a decision, it has to proceed forthwith to implement it. Or in this case, just to back up a touch, the minister may accept, reject, or vary the board's final decision. So here we're just saying that the minister decided to reject it. So in that case, once the minister has come to the final decision, it has to proceed to implement the decision, which could mean recommending to the GIC to list the species, and then the GIC amends the species at risk list by adding the species. And so at this point, it's, hopefully there's been a good dialogue, but if there's still disagreement, then one possibility is to bring the matter for judicial review, which isn't always the best thing, but there's not always, that's kind of the end of the line as far as the Species at Risk Act goes. But hopefully through good dialogue, the minister and the board would come to the same decision. So next slide, please. So I'm just about done, and then we can have a discussion and chat. But there's been a lot of changes since 2002 when the Species at Risk Act became law. And so since then, there's been the Labrador Inuit Land Claims Agreement, the Nunavut Inuit Land Claims Agreement. Canada signed on to the UN Declaration. Canada enacted the UN Declaration Act. There's been the Inuit Nunangat policy. There's been the change to the Interpretation Act, setting out the Universal Non-Derogation Clause. There's been the Inuit Nunangat Cabinet Directive and court decisions, not all of which are directly on point, but there's been a few. And that's actually the end of my presentation. We can go to the next slide. And yeah, thank you for listening. It was pretty high level, and it's sometimes hard not to get into the weeds with that act, but I'm happy to answer questions or have a discussion or whatever you like.
Well, thank you very much, Dawn. And I'm not sure if we have questions in the chat. I know there were some questions as you were speaking. So I'm not sure if we'll have more. Sometimes people follow up with questions afterwards by email. We have Dawn's email here. So if you don't have a question that has fully crystallized at this point, but you want to ask her a question later, you know how to get in touch with her. Really appreciate. I liked your picture of the polar bears in particular this morning. So. This is very good. So thank you. And I'm sure that nobody minds getting a bit of their lunch hour back if we end up finishing a little bit early as well. Okay, well, looks like we do have some messages in the chat. I just want to see if we have. looks like maybe those questions actually were addressed.
Okay.
Did Kosowick exist before Sarah? And I believe that he did actually ask that, you did address that already. Okay, well, seeing no further questions, thank you again, Dawn. We really appreciate you giving back to the Lost Society of Nunavut in this way, and I look forward to speaking with you again soon. And thanks to everyone who joined in today. I hope we can enjoy some warm weather in some places. I know there's some storms up in Nunavut today, so stay warm, everybody.
Okay, thank you everyone for coming.
Thank you.